Okay, hello. Attorney Nate Amendola, Criminal Law in Plain English, where it's my job to explain to you how criminal law works using plain English, because it's a difficult thing to understand. So today we're going to talk about an arraignment. What is an arraignment? An arraignment is a criminal defendant's first appearance in court. In order to understand what an arraignment is and how it works, let's just back up a little bit. How do you get to court? Typically, there's, I guess, three ways. You've been arrested, right? And you're going to be brought to court. You have been summoned to court, something called a summons arraignment, or you've been indicted, which is in superior court. So when one of those, you've been arrested or you've been summoned to court, when those one of those things happens, you've got your first appearance in court. This is when you're going to stand in front of the judge. The prosecution's going to be there, and your defense lawyer is going to be there, and or if I guess you waive you sign a waiver and say you're going to represent yourself. I guess it's just going to be you. At this time, your case will be called Commonwealth v. Johnson or Amendola or whatever it is. Typically, the charges are read out loud. Whatever the charges, assault and battery, family member, rape, whatever it is. Although your attorney can waive a formal reading of the charges, a bail warning will be given by the judge that says, this is you're being released on bail or whatever it is. If you violate a new offense, or excuse me, if you catch a new charge or violate your conditions of release, something like that, your bail can be revoked for up to 90 days. At that time, the judge will inquire to the prosecution whether there's any issue of bail, which we'll talk about in a different video, and you are officially part of the system. A PCF number will be generated for you. I think that stands for Probation Central File. Every person who's ever been arraigned, whether the case gets dismissed, not guilty or guilty, whatever it may be, is going to get a PCF number. I guess you can kind of think about it like your social security number for the criminal system. This isn't good, right? Because I guess, this means you've got some sort of record. I think when people typically talk about record, they mean like convictions, but you've got a record. If you're in the system, right? There's a record of you being in there. If you've never been arraigned before, and I hope it never happens to you, you don't have a PCF number, so I guess you don't have a record. Every person that gets arraigned gets assigned a PCF number, and it will generate what's called a BOP, a BOP, Board of Probation record, and you're officially into the system. It can be difficult for people to retain private attorneys prior to an arraignment because they've either been arrested and they're going right to jail, or in the case of a summons arraignment, for various reasons, which we'll discuss later how that happens. At that point, they can bring a private attorney with them. If before you get to your arraignment, you typically, especially in the case of a summons arraignment, you meet with probation first. You give them you have to do this. You give them some basic information. They just want to make sure that you're the John Smith that has been summoned. And then they're going to do ask you some questions about your financials to determine whether you're indigent. As folks know or should know, if you can't afford an attorney, the state will appoint a public defender to you, and that will happen at the arraignment. That will happen whether or not you can afford a lawyer. If you haven't brought a lawyer with you, or you can't afford one, somebody will be appointed for purposes of bail or perhaps for the case in chief. So you will not be there without a lawyer unless you tell them you don't want one or you got one coming, or for various reasons you don't have a lawyer there. But you will have one if the judge appoints a public defender to you, or if you bring a private lawyer with you. So an arraignment is a defendant's first appearance in court. Typically, the judge does not ask you, at least in the district court, how do you plead? It's not guilty pleas are automatically entered. Lawyers typically say, I am Nate Amendola for the defense. I waive a formal reading of the charges and ask that not guilty pleas be entered on this gentleman's behalf. That's typically what I do. I don't think you really need to say ask that not guilty pleas be entered because that's sort of automatic, but that's what happens. Again, an arraignment is the defendant's first appearance in court, booked into the system, bail argument is heard, and then the person hopefully is released, comes back, and kind of deals with the underlying charges. So, in plain English, in a nutshell, that is what arraignment is. Should you bring a lawyer, or do you need a lawyer there? Well, yeah, because if there's going to be an issue of bail, you're going to need an advocate there to help you navigate that process, especially if there's a dangerousness hearing, which we've talked about, or a large bail argument, and we've talked about those in other videos. You're going to need an advocate there for you. So that is how arraignments work in plain English.